Hi, thank you for tuning in. Welcome to the It's Your Money and It's Your Estate workshop series brought to you by our nonprofit organization, Financial and Estate Literacy. Our mission is to empower people like you to take control of their finances, their estate, and charitable giving decisions. For the past 25 years, our founder, Peter Kote, and our entire team have been providing these free, unbiased, and accessible 6 weeks programs all over Orange County, California to help you make informed choices that align with your unique needs and values. Now let's take a quick look at our website, iyme.org. On our homepage, you can easily view our schedule, which has all the information for these webinars, as well as the in-person workshops. You can also register for these webinars straight from the homepage. Now, if you click workshops and select the series of your choice, you'll find the topics for each of the weeks of the program. Each of those pages will have the recording of the webinar, which is usually posted about 3 to 4 days after the live webinar airs. Underneath that, you'll find the general workshop documents, which are our workbooks, which will guide you through the series, our booklets, as well as the very important Ask First form, which is very useful anytime you want to retain someone's services. Depending on the location where you take our classes or whether it's an online webinar, you'll find the speaker's presentation as well as their signed Ask First form. If you scroll all the way to the bottom, you'll find a selection of updated articles curated by Peter Kote, which are relevant to the topic of the day. Lastly, I want to go to our sponsor page, because without the support of our charitable sponsors, this program would not be possible. Now, let's start the program. This webinar is the first session of the It's Your Estate 6-week workshop series. The topic for today is overview and estate law changes, and our guest speaker for today is Steve Giammichele. Enjoy the workshop.
Good morning,
everybody.
Good morning. Hey, let's introduce you. You're going to be our first presenter. By the way, Steve does not get anybody's names, contact information, and you're not going to get a call from him. He's way too busy for that as well. Since you're going to be our first presenter and our first person that kind of gives an overview, I not only want you to talk a little bit about yourself, but kind of about the estate planning field and estate planning attorneys in general. So let's go to your Ask First form first.
Sure.
And Eugene is going to bring it up. So first of all, we'd like to know about your education. You've got a bachelor's and a master's degree, and I'm assuming that is the Juris Doctorate.
Yeah. I have a bachelor's of science in finance, real estate, and law, and then I have a Juris Doctor degree, which was law school, and I have I'm licensed in California and Washington currently.
Yeah, so. And you have many more years experience than just on the 8 years, because you spent quite a bit of time working for law firms while you were going through law school. Isn't that correct?
Yeah, no, I worked for several law firms. I was a clerk at the courts, a judicial intern, things like that. And it's actually about almost 10 years now, actually. Yeah. I need to update that.
Yeah, you do. Steve is not one to boast about himself, so we're going to boast a little bit for him. One of the things, too, if one of his other credentials and licenses, besides just having a state bar license, he has what's called a specialty license. You're a certified specialist in, is it called the probate area?
It's estate planning, trust, and the state law. So it's a certification through the California State Bar. And you can look up whoever has that certification on the California State Bar website, similar to the California just State Bar license in general.
Okay, but it's but not everybody who practices in the estate planning area has this. And why is it important?
Yeah, so the specialization requires you to have a certain amount of experience in the different areas of estate planning, trust and estate law, and you have to pass an additional exam, which is essentially like a specialized bar exam.
Yeah. So, and if you were going to hire an estate planning attorney or any attorney, please look them up. You know, on the California State Bar, there are many attorneys are disbarred or have disclosures, and you want to make sure that they're in good standing with the Bar Association. And so here you have Steve's, and you have a license number. You know, can somebody from out of state, like say Arizona, Colorado, Nevada, do a workshop like this and call it an estate planning workshop? Is that against the law?
I think they can do workshops, but as far as actually planning, like for educational purposes, it's a little bit different. But actually practicing law, the license is by state. So,
Yeah.
And there's some exceptions to that with federal law, but generally they have to be licensed in that state.
Yeah. Yeah. But anybody can do these workshops or a seminar or a free dinner program and the like, and they don't have to be licensed here in the state of California to do it. So if you're going to go with someone, please make sure that they are licensed in the state of California. The other thing I usually ask is that is there any other areas of law that you practice in?
So I only do estate planning, trust and estate litigation, administration. So only probate, trust and estate related areas.
So what, I'm not asking you to speak negatively about other attorneys, but you know, if I go on the web, on the internet, and I look up attorneys and I see estate planning, I mean, up pops about 100 different attorneys. And when I go to their website, it looks like they practice in about 10 different areas. You want to comment on that?
Yeah, it depends. If you're doing an estate plan or looking to set up an estate plan, you want to consult with an estate planning attorney that primarily does that or does just a couple of areas of law. Because oftentimes what law firms or just attorneys in general will do is they want to keep the client in-house because they don't want you to talk to another attorney because they're afraid of losing business. So a lot of people may say they do estate planning and they very well could be capable of doing it, but they may not know all of the ins and outs of estate planning, the risks, things like that people would want to know when they're setting up an estate plan. And so if you go to someone who doesn't regularly practice in estate planning, it can cause problems, not always, but
yeah, it can. But that goes for every field. You know, if you're going to do a divorce or a family law issue, go to somebody who practice almost exclusively in the family as their primary in the family law area. It's the laws are very complex and not easy. And if you just dabble in it, you're not going to be an expert in it. So you practice law and are active license in the state of California, which is great. You put your client's interest first. And let's scroll down a little bit. And first of all, how do attorneys in general charge for their services?
So typically there's three ways. It's possibly to be a flat fee, hourly, or a contingency. And so a contingency fee agreement means that the compensation for the services, I should say, are based on some sort of an outcome.
So that's usually a personal injury.
Yeah, typically with personal injury, it sometimes occurs in trust and estate litigation, but fairly rare. And then there's flat fees, and so some attorneys will charge flat fees for things like an estate plan or um, preparing a contract or certain items where it's a standardized form. And then there's hourly, which is the majority of what attorneys charge, and that's can be done pretty much for everything. So
Yeah.
on our end, we used to do flat fees for estate plans, but we no longer do those. Occasionally, we'll do a flat fee if it's a very minor thing, but typically we do it only hourly at this stage.
And what is your hourly rate for your office and for
So
yourself?
my hourly rate is $550. Our associate attorneys are $400 an hour, and our paralegals that are $200 an hour.
Okay. So let's say I come to you, I have $1 million estate, I'm married, I have one child, I have an investment account, and I own a home, and I want to do an estate plan for myself and my wife, and I come to you, and would you give me an estimate?
Yeah, usually for a married couple doing a full estate plan, it's usually about $2,500. And that's similar to what a flat fee would be, and which is why we switched to hourly. The main reason we made the switch is to allow people to control the cost of their estate plan. Um, I always tell people the more certain you are about what you want, the cheaper it's going to be for you, because the less back and forth there is, the less time is involved in preparing an estate plan.
So do you give any kind of a free consult or a phone call or an in-office visit, or is it strictly on a fee basis?
Yeah, right now we do free consults to talk about what someone needs. Not a whole lot can be discussed during that consult, only because, you know, typically, unless someone has a very straightforward estate plan, very simple, like it's all going to the kids, they just want, very basic, that can be discussed a little bit more. But oftentimes people have more issues that they want to talk about. And so the initial consult that we do for free, not a lot of time can be spent in it, but we do have a whole process for it in the estate planning.
So
Where we
15,
delve
30
into it.
minutes, is that kind of approximate good
Yeah.
rule of thumb? Okay.
Yeah.
Uh, in a law office environment, let's say, do you charge when you look at somebody's estate plan and they already have their documents drafted, but it's 10 years old, let's say. What do you typically do in that particular case?
Well, you would look at the documents to see what it says, and we kind of go over it with people to explain what the terms are, if that's still what they want, go over any issues that we see. So there's not always a need to change it, but sometimes it'll say things completely different than what someone thought they said.
What is the difference between doing an amendment and a restatement for an estate plan?
So a restatement is essentially an amendment of the entire trust document, whereas an amendment is anything less than the entire document.
And then if you take somebody else, let's say they had gone to another attorney and the other attorney drafted the documents, when you come in, are you now responsible for the entire estate plan?
It depends on what you're doing. I mean, typically you're not responsible for what the prior attorney drafted, but that's what a lot of attorneys will do restatements for, is to update the documents entirely. So, for example, and it's usually cheaper to do it that way, because if you're doing an amendment, who knows what the other attorney put in there? There may be other provisions that may need to be changed because of even though the potential client may want to change just one section, that section may affect other provisions in this trust.
Yeah.
And so sometimes the attorneys won't feel comfortable doing it as just an amendment. Sometimes I'll do it. It just depends on the circumstances.
Yeah. Yeah. We're going to eliminate the word depends from your talk today, if we can.
We'll see.
It's impossible because every estate plan is unique. I mean, we tend to think that that it's all boilerplate, but it isn't. You gotta really understand the client. I mean, the initial interview, usually, how long does that take?
So we anywhere from 15 to 20 minutes to an hour and a half.
Yeah.
It really depends. Some people have more complicated situations. Some people want to leave gifts to 30 different people, and or people have a lot of questions about different types of trusts, which you'll get into later at the workshop, I know. But it really depends on the complexity of what someone wants, because you never know at the outset. Even the consult, it's hard to tell, and even after the draft stage, people see it and they change their minds because they're like, this is too complicated.
Yeah.
So.
Eugene, if you scroll up just a little bit on the licenses, if Steve had a securities license or an insurance license, would that make him more of an expertise in that particular area, or would you think otherwise? If I saw an attorney having other licenses, I would put up a real caution flag, because you can't be a good estate planning attorney if you dabble in securities and insurance as well. Not only that, but you can make a lot more money in the insurance and the securities area than you can practicing law. So when you see other licenses, really ask, why does the person have these licenses? And more than likely, they're selling you stuff. Now, if you scroll back down and you see this section that says financial products or affiliated organizations, and Steve puts false. He does not sell insurance, mutual funds, or financial products, and is not affiliated with anyone who does. There are some law firms out there that have wealth management offices, and just down the hall is somebody who's selling you an insurance and annuities. Be particularly careful of that. I would say, you want somebody who doesn't. Do you accept or give referral fees, Steve?
Not to non-attorneys. I mean, occasionally we'll have referral fees on litigated cases or something, but
but normal practice, that just doesn't happen. So anyway, so this ask first form, how long did it take you to complete?
I don't know. This was a while
5
back.
minutes.
Yeah.
It's not a big deal, but you learn a lot from it. So let's go to the presentation. And let's go to the next slide. That's where Steve's office is. Steve, do you want to tell us a little bit about your practice or about yourself, other than what we just talked about, if you have an opportunity,
Sure.
if you like?
Yeah, our office at our firm, we practice trust and estate litigation, estate planning, trust administration, and family law. So we have a certified family law specialist as well, and he handles dissolution and most of our litigated matters. So
good combination.
Yeah.
All right. Our agenda today.
Yeah, we'll be talking about an overview of what an estate plan contains, and we aren't going to get into too much detail. I know we'll talk about the estate planning documents and all of that briefly. We'll discuss kind of the time and effort involved in setting up an estate plan, the certified specialist. I think we already went over that one a little earlier, but we'll discuss it a little more. We'll talk about the reasons people delay in setting up an estate plan and ways to kind of help convince yourself to go forward with the process. And then we'll discuss capacity as well as it relates to an estate plan, the consequences of not having an estate plan, some of the recent law changes, and then we'll conclude.
Well, yeah. At the end, Steve will do a little bit of a Q&A. So hope you could stick around for 5 or 10 minutes afterwards.
Yeah, no problem.
Okay. The estate planning documents, what are they?
Yeah, so the basic estate plan consists primarily of a will, a trust, a power of attorney, and an advanced healthcare directive. So the will and the trust are primarily designed to come into play after you pass away. The will does not become operative until you pass away, whereas a trust is operative while you're alive, but generally won't come into play with a successor trustee until after you pass away. So the difference with the trust is that there's a trustee, and so if you are the trustee and you become incapacitated during your lifetime and aren't able to manage the trust, you would have a successor trustee named in the document to take over management of the trust, whatever the assets of that trust may be.
And it's so a trust kind of helps you avoid a conservatorship potentially.
Yeah, it can provide an alternative to a conservatorship. And so, the primary documents that will help avoid a conservatorship are really a power of attorney and an advanced healthcare directive. So these are the private alternatives to the court conservatorship proceedings. The power of attorney, which is typically referred to as a durable power of attorney, which means that it survives your incapacity. That document allows you to appoint an agent to make financial decisions for you. And it doesn't necessarily have to be when you're incapable of making those decisions, but a lot of times people will do a durable power of attorney when they get older because the bills are getting overwhelmed. And it's not that they lack capacity, it's just that it becomes a lot to deal with. And so they'll put a child or whoever in as an agent, and that person will assist in things like bill pay and whatever other financial matters there are.
Yeah.
The advance. Yeah.
Go ahead.
The advance. Sorry.
Go ahead, Steve. I'm sorry.
Yeah, the advanced healthcare directive is the personal or medical alternative to the power of attorney. So the advanced healthcare directive allows you to appoint an agent to make medical decisions for you. And there's other decisions they can make as well, some post-death, dealing with organ donation, disposition of remains, things like that. But those two are only operative during your life, with the exception of the healthcare directive. There's some post-death authority, but those two documents allow people to make personal decisions for you. So that would be things related, like the power of attorney, some personal financial decisions, maybe things related to like a retirement account. So in theory, if you set up a full estate plan, you want to transfer the majority of your assets into the trust so that you bypass the probate process, because that's expensive and costly. And we'll talk about that a little bit more later. But as far as the trust goes, only the trustee is going to have authority to manage those assets. So if you have a different person who's named as an agent and is not the trustee, they won't have authority to manage the trust assets, but they might have authority to withdraw things from the trust. And so it gets a little bit more complicated than that if you put different people in those roles. But typically, people will make the agents under the power of attorney, healthcare directive, the trustees under the trust, and the executors under the will, all the same person or the same people in the same order. And the reason for that is more consistency based.
You know, I get a lot of questions usually about the difference between people who are married and individuals who are single. Do both have to do or would you recommend both, whether you're married or single? Should you have an estate plan, and what would be the difference?
Yeah, it should you have an estate plan? It I know you don't like it, but it does depend, right? I mean, if you're married and you have everything jointly held as community property, if you don't have an estate plan, it may just pass to the surviving spouse, but it doesn't always, because a lot of this is all dependent on how title is held to assets. And so
Title,
you,
title. So
yeah,
explain a little bit about, a lot of people have their property titled in joint tenancy. And what, talk a little bit about that.
sure. Yeah, so people will hold it's yeah, it varies. It's changed a lot. So if you're married to someone and you own real estate, depending on when you purchased it, who your broker was, you could have one of three or four different types of ways of holding title to it. One of those is joint tenancy. Another maybe as community property or as community property with right of survivorship. Effectively, the ultimate effect of each of those is that it will pass to the surviving owner. But with a joint tenancy, there's significant tax basis issues that change depending on how the title is held. So with a joint tenancy, only one half of the property will get a step up in basis, whereas with community property, the entire thing will when the other joint owner dies.
So for a married couple, it's recommended either have a living trust or have it as community property with right of survivorship.
Yeah.
Yeah.
Yeah. And so, yeah, the difference with like whether you set up an estate plan as a married couple, it really depends on primarily what your intent is, right? So if you just want to give everything to your spouse, you could set beneficiary designations up on things like a retirement account, hold it as community property with right of survivorship, and it would pass to the survivor. But that's usually not the only answer. And then what happens if you both die at the same time, right? It can create other complications because some people will be married and say, oh, you take care of it when I die, or the survivor of us will deal with it. The problem is if the survivor passes away soon, which is, I will tell you, I have seen is much more common with very long-term marriages, is people die within a very short period of one another. And if that happens and they don't have time to set up an estate plan, whatever your wishes were or intentions were wouldn't be put into writing, and it's going to pass pursuant to whatever the default is in your situation. So it would be the heirs at law or probate, expensive, you know.
Yeah. And when you do a will, each person if you're married has to have a will, right? It's not a joint will.
You can do a joint will. Those, they're generally not recommended. They can be changed. That's trust, probably more complicated.
Yeah. In a trust, usually the married couple have one trust.
Yeah. You usually have a joint trust and you'll each have a separate will. And they're called pour over wills if you have a trust, because the idea of that is to act as the ultimate fallback to get everything into the trust to the extent you couldn't get it in otherwise. And the joint trust is set up in a way that upon the first death, certain things happen. And that could be that there's a split of the assets, that there's no split. It could become irrevocable. It could stay irrevocable or changeable by the survivor. For married couples, there's several ways you can handle the assets, because when you're thinking about doing an estate plan as a married couple, you have to think, what do you want done when one of you dies? Do you have different interests or different people that you want to leave assets to? Do you care? Is your primary goal to give it all to the survivor, which is pretty common, but not always, because if you have a larger estate, well, they'll be taken care of. I'd like to give money to whoever or a charity or something. So,
or second marriages or third marriages, or you come into marriage late and you have a lot of separate property. All of that can be defined in the living trust, right? Because the living trust is an agreement.
Effectively, yeah. And the idea of it is you have to, one, figure out what you're going to do after the first death, and then how are the assets going to be handled, right? Is some portion of it going to be irrevocable, or can some portion of it be changed? And then what happens on the second death, and when you're talking about splitting a trust and making half of it irrevocable, there's risks associated with that too, right? Because when you have an irrevocable trust, you're going to have a tax return that you got to file for it. and you're going to have potentially other risks depending on who the other beneficiaries are and what the trust says.
Yeah, and that's why we have an entire hour and a half on a living trust. So Steve is giving you a little taste as to some of the issues. When you're speaking about a power of attorney, does each spouse or have to have their own power of attorney?
Yeah, and typically each spouse, generally, not always, will name the other as their primary agent, and they'll name some successors in that role. And it's a common misconception that you can just sign for your spouse in things. On certain things, people won't care. Technically, you don't have authority to sign on their behalf unless they give you the power of attorney. And that comes into play with things like reverse mortgages, bank
IRAs, 401ks,
you know,
457 plans,
all that stuff.
Yeah, you have to have legal authority, and that's what these documents do. So the power of attorney, we remember we talked a little bit about joint tenancy with right of survivorship. Well, if you have in joint tenancy, by the way, if you have joint tenancy with right of survivorship and you want to change that to community property with right of survivorship because you just heard that is better for the step up in basis, will that change your property tax basis or have any effect on income taxes or any kind of tax whatsoever?
So if you change the form, it shouldn't have any effect on those things, as long as you do it correctly. So it is complicated because there's other forms that you send in when you record a new deed. You have to send in change of ownership statements, and they have, one of 30 different options that you could be filing this deed for. So you want to make sure you check the right boxes.
What do you charge to change a deed?
Well, it depends on what they're doing, right? If they're doing a simple deed, it's somewhere between $500 and $800. But a lot of times when someone has a title problem, it's more than a simple modification of just one deed. So,
yeah. And where do people find out for sure how they have title?
So you can go to the county recorder's office and pull the chain of title. You can talk to maybe a title company or a broker that might be able to pull a preliminary title report for you on the property. And that's if you own condos, real estate, but it's different if you have a cooperative unit in places like Laguna Woods, and I think Seal Beach as well has some of those. So with the difference, since I brought it up, the difference between those is a co-op is a stock certificate that you have for title, for those of you that don't know. And that's very different. They've recently changed the law on how those are handled, but essentially it's a stock certificate that shows you how title is held. And if you have a mortgage on the property that you purchased, that original stock certificate is what you need to change title. And that's typically held with the lender until you pay them off. So
legal authority, that's what these documents are about. To give somebody else legal authority if you want them to handle it. The will is only effective upon death. It has no impact during your lifetime.
No, you can change the will from time to time. People often will do that. The problem that people run into is they will change their will sometimes when they have a trust. And so the will may not have any effect at all ever if your assets are all in the trust.
Yeah.
So,
and when you have a trust and you have it, let's say your home in the name of your trust, does that mean that your how you have title, or do you have to state how you have title inside the trust?
So you don't have to, well, I'm not sure what your question is, but I think your question is, do you have to change the trust every time with title? And the answer to that would be no. And that's actually a pretty common question that I get a lot is, we'll get people that call in thinking they need our help, saying, hey, I bought a property, I need to change the trust. And the short answer is you generally don't need to change the trust at all just because you acquire property. The only pertinent issue is how title to that new asset is held.
How it's
And so if you're
recorded.
Yeah, so if you sell a house that you originally put into the trust, you can actually purchase it, and when at the time of acquisition, you can have them put the deed into your name as trustee or however you would like it held.
Yeah.
So
So for what you should do is list all your assets. Home. How do you have title? Do you have a title in the name of your trust? Do you have a title as joint tenancy? Do you have a title as tenants in common? Do you have a title as community property with right of survivorship? You need to know how you have title, because title is also going to tell you what kind of document do you need to use. If have a power of attorney, can I make changes in somebody else's trust?
you can, if you have the proper authority and the power of attorney, and the trust also
But
specifically allows that.
normally you don't, right?
Typically, no. Yeah. The standard is generally not to give that authority because it has a tendency to be abused.
Yeah. So how you have title determines what hat you're going to have on to help someone else out. So if you're married and you have things in joint tenancy or community property, you have legal authority to handle stuff for your spouse. But if they have an IRA account and you don't have a power of attorney, you cannot get into that IRA account. So that's why each person has to have their own powers of attorney. And we're going to have an entire session on the durable power attorney and the advanced healthcare tomorrow. I mean, not tomorrow, next week, next week, Friday. So let's go to, is there anything generally else that you kind of wanted, that common questions that you get when you first talk to somebody about this particular estate plan?
I mean, probably one of the most common is who you put in as trustees. Should you put co-trustees or children? And that's extremely common. I mean, that's always the question, right? Who do you put in that role or in any of these roles?
Well,
and
you can't
sometimes
finish
people
all
don't
your,
have anybody.
Yeah, well, you can't finish any of these documents unless you can name individuals.
Yeah. Yeah. So the short answer is, in all of these roles, it should be someone that you trust, because that's really what this is about. And even that isn't always the best option, only because it depends on how your medical condition continues, right? So one of the most common things with dementia is that you will turn against people that are the closest to you. And if that's a concern, or you see that it is on the horizon, it's something to talk to your attorney about, because it might be something you want to put in some other person into that role. And there's a variety of options for that. But typically, I won't recommend people put co-trustees in, just because that's the easiest way to end up in litigation over decisions. Because going back to title, right, how everything is held, if you have co-trustees, that means you're effectively putting two people on title. And whenever you have disputes with two joint owners, two people on title, you're going to end up in court to get it resolved. And that's assuming that no one, works out their differences. But that's one of the biggest problems with having co-trustees or co-agents. And the other issue is just who's making the final call, or do they have to make it together?
Yeah.
Is there a tie-breaking vote? Things like that.
I see older parents put their child on as a joint tenant on our house or a bank account. And what have they done when they do that?
A lot. And that's also a pretty common problem that people do, is they think they're bypassing the probate process the smartest and most effective way. The problem, again, with joint tenancy is it's a tax basis issue. And so when you do that, what you're doing is actually gifting half of your property to your child. And so technically there's other gift tax issues, and estate or a lifetime gift issues with that, but it is commonly done, and
And you give up trust.
unfortunately,
You
you
give
give
up
up
control.
ownership.
Yeah.
Yep, ownership, control. You decide, or you need to sell your house. Well, now you need their agreement. And if you have a falling out with that child, or and the other issue too is sometimes people will do it to the oldest child, thinking they'll take care of the siblings. And unfortunately, as time goes on, people say, "Oh, I remember that differently." I and so they don't want to honor the wishes, or they say, "Why would I give up this property?"
Yeah.
Because the converse of that is then they also have their own gift tax problems, because it's not a gift from you at that stage once you're deceased, it's a gift from them to their siblings. So
Speaking about
it
deeds,
gets
yeah,
messy.
it's a big issue. Speaking about deeds, is that part of the package when you do an estate plan, looking at all the deeds to the different properties? And would there be an extra charge to change a deed in your practice, Steve?
Yeah, so typically we do the deeds as part of the estate planning process, for whatever someone wants. Depending on how many deeds are needed, there's just a different cost, and that's one of the reasons we switched to hourly, is because we never know at the outset what problems we may run into.
Yeah, yeah. When you start looking into how deeds are held, it's quite interesting. Let's go to the next slide.
Yeah, so this slide really lays out what time, effort, and the cost of doing an estate plan is, right? So the time commitment is really the estate planning process, and it's sort of what Pete mentioned earlier, is gathering all of this information. And part of our process is we meet with an estate planning client, and we'll kind of go over what the assets are, what issues that we may see, if you have title. All of that can kind of be reviewed during that process. Not everyone wants to, go through all of that. They just want to set up the documents, and then they'll handle it all later. The problem with handling it that way is that if you don't do it all at once, it can be overwhelming in some situations. And if you don't do it all together, sometimes you'll forget to transfer assets into the trust, or for whatever reason,
But
just
they
don't
need
do
to,
it.
but you need to know their family history. You know
Yep.
who lives
That
nearby.
that
Who,
that's important.
yeah,
And
who
that
is.
and that's one of the things I always tell people. I always say, your family. I don't, and I put that in there as well. We don't know who your family is or what the dynamic is.
Yeah,
So just because you say I want my kids in there, I mean, we ask. I ask at least. I don't know if all attorneys do, but I ask kind of what's the relationship between the kids, and a lot of times it's even self-reflection that the clients have to do, because we all want to think our kids all get along, everything's great, but if you really reflect and say, oh, they've had problems over the years, all of that could come back tenfold once you're gone, because the common connection between them is no longer there. And losing a parent is probably, you lose a parent twice in your life, right? Maybe a step parent, but you never know how someone's going to react. And if there's problems right now while you're alive, there's probably going to be problems later.
yeah.
And
your attorney needs to know this, so they can make recommended solutions, and it takes a little bit of time. This is why, if you see an estate plan advertised for $500 or for $1,000, all you're getting is the documents. You don't get any consultations. You don't get a review of the title. Because it takes time to learn about that stuff from your family. And your estate plan, especially the trusteeship and the distribution, is totally unique to you. So time commitment. Once you have a draft together, then you go over the draft with the couple or with the individual.
We do, yeah. So our process is, once we're retained, we kind of go into a deep dive of what the assets are, the family dynamics, what the clients want, and then raise questions, give thoughts to people. It doesn't always, after the initial kind of deep dive into a person's situation, it doesn't always lead to drafts, because sometimes people will have more questions. And then once they get the drafts, once you're at that stage, a lot of times people will have other questions, because a lot of people, everyone, not everyone, but a good chunk of people will say, I have a really simple estate plan. I just want
I
X,
always
Y, and
run
Z.
for the hills when I hear that. I only have a simple plan. Nobody has a simple plan, because we're all unique. We all have issues. So, and we have this belief. The problem is that here in Orange County, we're a major metropolitan area, and nobody's going to help you out unless you have the proper paperwork and it's stated properly in that paperwork about your legal authority. And because what happens, well, we're going to get there. What happens if you don't have the document? We talk a little bit about the effort involved, the cost. We talked about that as well, flat rate, hourly rates, etc. And do people have a hard time asking you about your fees or how you charge, or, you need that conversation up front. Isn't that correct?
Yeah, honestly, most people don't ask me. I try to tell people, so that I try to be very clear about how we charge.
Yeah.
But a lot of times people don't even really ask that, frankly. But it's, there's a different flat fees, hourly rates. It could be different depending on the firms, but typically they're going to cost roughly the same price, because the flat fees are based on how much time they're spending anyway. So. And I would actually add to that too. Some firms actually charge hybrids of flat rates and hourly. So it's important when you are retaining an attorney to read the fee agreement to make sure you understand the fee structure.
We had a question on title with a certificate of deposit. How do you recommend certificates of deposits title be held? Because they usually have a beneficiary designation as well.
Yeah, so good question, actually. And again, it depends, right? So it's all of these documents, and a lot of people try to, determine what they're going to do with one asset. The problem is they're all really interrelated, right? So if you're giving everything to a single person, it may not make a big difference if you put a beneficiary on the CD, and then they're also a beneficiary into the trust. The problem is, if that's the case and that person dies, that beneficiary designation would fail. And then you may need to have an alternate set up. You may not have an alternate. So the question comes up, and I always tell people, well, this is what happens. I try to run through hypothetical scenarios with people, and sometimes we'll go down a rabbit hole and get into a place where we're talking about something that's so unlikely. But I want people to understand, like, well, this is how it's going to work if this is how you set it up, right? Because while things are very unlikely, they do happen,
Yeah.
And it's
so CDs, you should have it in the name of the trust, and you should have the trust as the beneficiary if the bank asks for a beneficiary designation. If you have a bunch of different assets with different names and different beneficiary designations on there, it gets quite confusing. Yes, Eugene.
Yes, I'd like to add to that. We had recently interacted with the bank where they would not accept the newest trust that was restated and amended, because they asked for the beneficiary of the trust when it was in effect at that time. So you should let them know anytime a trust is updated, because they'll sometimes revert back to the original trust that they have on file.
Yeah, banks and financial institutions have their own rules. So an attorney can do the most beautiful document, and you go to your financial institution, and sometimes the manager or the person there or the bank policy is completely different than the law. And speaking of that, do trust and powers of attorney go out of date?
Well, go out of date. So the short answer is they don't go out of date because they are valid as long as you don't revoke them or modify them. But the purpose that it was originally intended for might go out of date. So the purpose that you did it or however you set it up might no longer be your actual purpose or intent anymore. And that's usually when people have set something up, 10, 20 years ago, sometimes 5 years ago. It's usually, I recommend people look at their documents and see if they need updates every roughly 5 years, because you may forget, oh, I put, Uncle Joe in there and now he's dead. And then you want to update it and say, oh, you know what? This person I put as the alternate, I don't know if I want them to be the next trustee in line, or people move away too, and that's kind of what you alluded to earlier, Pete. I mean, in theory, you want someone that's going to be close by and willing and capable of helping you in your time of need. Because if you put someone, halfway across the country into your estate plan to act, they may not physically be able to help you, and they may not have the means to travel here to help you. And so
I see
a lot
these
of considerations.
I see these documents today as not so much after death planning, but I see these documents more about incapacity, about what happens if I have Parkinson's disease, who's going to care for me? What about if I have dementia? What, is there provisions for somebody to care for me? A stroke, multitude of issues that they can keep you alive, but you can't handle your own, you don't have the capacity to handle your own financial or personal issues. And this is where you really need these documents, because you've given this legal authority to another person to care for you, and you're still breathing. And once you're dead, you're dead. So let's go to the next slide. And we got a couple of questions. Should joint owners and bank accounts be more advantaged than the trust when dealing with the bank when one passes away? Banks, banks like living trusts much more than any of the other documents. I don't know if that answers the question or not. And Eugene can type an answer for you as well. So the other one is, so if you put a CD in the trust, can you state the bennies be listed as what percentage goes to each benny when you pass away? I'm going to expand on that question. Should you do specific gifts, or should you put percentages for beneficiaries when you're making a gift, or when you make a distribution?
So the simpler you can make a distribution scheme, the less likely anyone's going to litigate over it, the less complications in the administration later. So just to specifically answer this question, what they're saying is, I put a CD in here, can I say that this CD gets split percentage-wise to different people? I believe that's the question. And the short answer is you can, but here's the problem with it, right? And I've run into this on different trust matters, is the attorney will draft it and say, this CD, this account number that holds this CD goes there. Well, the nature of CDs is that they roll over, and you're going to get different numbers. You might acquire more. And if you put it that specifically in the trust, that CD that you specifically gifted may no longer exist when you die. And so that gift could fail. It might not, but it might also lead to someone having to go to court for instructions on what to do.
Yeah.
So
name the trust. Let's say we talked a little bit about a certified specialist. So very small percentage of estate planning attorneys have the specialist designation, because it's literally another bar exam, and nobody wants to take another bar exam. So let's go to the next slide. Yeah, this is a good one. Let's
Yep.
talk a little bit about it.
Yeah, I mean, it's we always joke like, why did everybody wait? I mean, there's a whole lot of reasons why you wouldn't do an estate plan, right? I mean, you don't want to acknowledge that you will never be able to handle your affairs is probably the biggest reason. Death, we all know we're going to die, but it's not going to happen for a long time, right? And it's hard to come to the realization, well,
It's always going to be
the
10
life,
years off.
yeah, exactly. And you never know what happens. There could be a car accident, a stroke. I mean, a variety of things could occur that just prevent you from doing an estate plan.
Yeah.
And I've had clients come to me, and I'll tell you, it's a mess. Because if you don't have an estate plan and you're unable to sign anything, well, you've still got bills to pay. You've still got decisions to be made, and that means that you're going to have some sort of a conservatorship unless you're able to consent and work with people. But that's not always the case. So, and a lot of people think estate planning is complex, and we've talked about a lot of this being complex today, but it really isn't that complicated for most people, right? The biggest problem most people have is that they don't have a comprehensive understanding of everything that they own, or they're really unclear about what they want to do with their assets. Some people, easy, right? It's like, I have a house, these bank accounts, a retirement account maybe, and I want to leave it all to my kids. Pretty straightforward. But some people will have, multiple bank accounts, things like that. And while there's a lot, you can consolidate, but even talking to an attorney, it can be a bit more simplified once you actually get into the process, because a lot of what we've talked about today is sort of all of the issues that you could potentially have, because we don't know who everyone is, and everyone could face a lot more issues than the ordinary person.
Yeah. And some people don't have children, or they don't, or they don't want to burden the children. And so on session week 6, we go through estate administration. But most attorneys know professional fiduciaries, and the attorney will figure out the personality and the skill required and make a recommendation that to you for the professional fiduciary to interview 2 to 3 different people and say, check these people out, come back, talk to me, and we'll figure out who is going to be the best person to fill that need. What you don't want to do is give it to a friend. I find that to serve those roles because they have to deal with your family, and sometimes friends don't know anything more than you do. So there's about 60 to 70 professional fiduciaries here in Orange County, and your attorney can really help you pick out the person who's best for you. Would you do that, Steve? I mean, is that kind of what you do if someone doesn't know who to pick?
Yeah, I mean, I can give you names of different professionals. Everyone has a different rate. They have different personalities. They're older, younger, men, women, you name it. And I always recommend really meeting with a professional if you're leaning towards that, because you don't want to put someone in there solely on the recommendation of an attorney, just because you may not like this person, or you just may not get along with them, or they may not get along with you. I mean, if you talk to them, it's similar to like an attorney, right? You shouldn't just go to the first attorney you see. You should talk to people, right? I mean, it's similar to doing contract work on your home, right?
Yeah. It's one of the benefits. It's one of the benefits of the workshop series. We're going to have multiple different attorneys. They'll have different rates, different personalities, so you can see maybe you want who to pick. But to pick up on Steve's point, there's nothing wrong with calling 3 different attorneys and checking them out and talking to them at least by phone. Find out their rates, personality, a little bit, and because a lot of trust is involved. If somebody, these documents, the trust, whether you're single, whether you're married, whether you're single, married with a woman, or common law, or you have a same-sex partner, this trust document is a contract and an agreement, and your attorney can develop that trust document to fit your needs and your desires. It's unique to you. So, and it has to be followed. No matter who you name in that document, they have to follow that document. Steve, do you want to make a comment on that?
Yeah, I mean, I would just say, I always tell people your estate plan can be really whatever your imagination can come up with, right? And some people, if you could do multiple trusts, right? So there's no need to just have one trust. That's typically what people do. But in some cases, a married couple that has everything separate, they may want to do separate trusts. I mean, there's options to talk to people about, or talk to an attorney, I should say, about, because it's like Pete said, I mean, everyone really is unique, and you know about your situation, and you got to tell the attorney, right? Because the attorney is the one that can give you the options for what's available, and hopefully come up with good, unique ideas to resolve whatever kind of difficulty you're facing.
But the more simple you can make it, the better off everybody's going to be. You're going to stay out of court, and the more complex that you make it, the more potential for problems. Let's go to the next slide.
Capacity. So capacity is one of those funny terms that is used, and it's used a lot, and not everyone understands really what it means, right? And we have the way we use it and talking to one another, we say, oh, they have capacity. Legal capacity is really different. And all legal capacity means, and you can, attorneys have a variety of different opinions on what it means, but simply put, capacity means the ability to understand whatever act it is that you're doing. And that varies with whatever that act is. So that means if you have a will that you handwrite and say, I want to leave everything to Pete, it doesn't take a lot of capacity to accomplish that, because it's very simple. It's a sentence. But if you have a complex trust that has a split with an A and B, it's a lot more complicated. And so does someone have the mental ability to understand what all of that means, what their assets are? It varies by situation. And so a lot of people will say, and this is where you get more into litigation issues, but a lot of people will think someone has capacity because they talk to them and they have friendly conversations, and, oh, they could tell me what they want. And it's very different when you're talking about estate planning and things, right? Because someone needs to understand what their assets are. They need to understand who their heirs are, what the effect of the gifts that they're putting under a trust are. And if they don't understand that, they may not actually have capacity to execute a trust or a will, but powers of attorney and healthcare directives, they might. So you might have capacity to sign some estate planning documents, but not others.
And so it changes. If somebody gets dementia, I mean, all of a sudden family members become the enemy. The successive trustee becomes somebody they're trying to control me, so I'm going to get rid of them. It's capacity is huge.
Yeah. And there's people that don't have capacity, but you would never know it by just talking to them. But as you get into more complicated subjects, you see like, oh, they actually don't, like, what they're saying doesn't make any sense, but they're able to carry on. People are able to carry themselves very well. And even a note on the dementia issue, even people with dementia, depending on the type, I mean, you could have full capacity at certain hours of the day and totally understand everything. But then that hour hits and you don't, you start saying strange things. Yeah.
They even have a name for it, sundowner.
Sundowners,
yeah. It's we're complicated human beings when our brain starts acting up. And talk a little bit about the conservatorship. We're not going to spend a lot of time on it, but it's something that you really want to avoid.
Yeah, so it's commonly understood that conservatorships mean that you lack capacity, and that it really isn't what it is. What a conservatorship is there for is if you're unable to manage your either financial or medical affairs. And even a lot of attorneys will say that it has to do with lacking capacity, but that's really not what the court's determining. And there are certain determinations that affect your ability to do certain things. But the gist of a conservatorship generally does mean you probably don't have the capacity to manage any of your affairs anymore. And if you're going down that path, it's a very expensive, and you've heard anything in the last couple of years about conservatorships. They've changed the law drastically. And unfortunately, it was in a way to go against conservatorships, which means that the California policy is very anti-conservatorships now, which is good and bad. But there's also a lot of additional costs that people don't think about, such as court-appointed attorneys, guardians ad litem. They can be very expensive. I generally try to steer people away from those, and that's one of the biggest aspects of avoiding the need for a conservatorship is setting up an estate plan, even if it's as simple as a durable power of attorney and a healthcare directive, because those two documents can go a long way because you appoint someone to make decisions for you and help out. But if you don't have those and you're in need of help, and even if you don't have anybody, the county may get involved and have to open up conservatorship proceedings. Unfortunately, it's one of those things that the legal system isn't fully caught up with and able to accommodate.
And they're not social workers, the county, and they don't. Because it is social work, taking care of other people, and but conservatorships is especially if you have family issues. One child wants this, another child wants that, and one thinks that they should control mom, and the other one thinks that they're not good for mom. And boy, I'll tell you, it gets ugly, and it's not because of the court system, it's because of the family situation. And everybody, the legal system is an adversary system, so you don't go into court finding the best solution. You go into court arguing for one position or another, and it just doesn't work very well with mentally ill and conservatorship cases. So you want to avoid it. So if you're single, please put together a living trust. That's the easiest way to manage another person's estate. But absolutely have a durable power of attorney and the advanced healthcare directive. And we're going to get into that next week for a whole hour and a half. Let's go to the next slide.
The consequences of not having an estate plan can really be expensive. And so conservatorship is just one aspect of it. And that's during your lifetime, right? And to me, that's one of the most important things, because I always say, who cares what happens once you die? You're dead, right? If you if you spend all of your money, whatever, I mean, who cares if someone inherits from you or something? You earned it, it's your money, right? So, but to the extent you do pass away without an estate plan, don't need a conservatorship, your assets are going to have to pass through the probate process, and that depends on whether you're going to have court proceedings or it can be done out of court. Generally, in California,
what's intestate succession?
So intestate succession is the default scheme that the state has laid out for how your assets pass when you have not otherwise directed it. So that means that there's a whole chart of it, but it's called the table of consanguinity if anyone's interested. And it goes first to your children. If you don't have children or you have children have predeceased you and they leave grandchildren, it would be grandchildren. Otherwise, it would be parents, siblings, grandparents. It goes back and forth, up and down in your genealogical tree. But
A couple of questions on intestate succession. What about an adopted child? Is that are they they're treated as an intestate?
Yeah, they're treated the same as a regular child.
How about a common law marriage?
So California does not recognize common law marriage. I think there's only 1 or 2 states that does.
So if you're living with a partner for an extended period of time and you think that your assets are going to go to either partner, they're not. They're not part of the intestate succession. You need a document, a will or a trust that says who those assets are going to go to. Probate. What happens in probate? We're going to get into more detail on a probate. What's the purpose of probate?
So the purpose of probate is to essentially wind up the affairs of a deceased person. So it's really similar to winding up a business. If you're familiar with that at all, what it means is you're essentially liquidating the person's assets, filing final tax returns, paying off creditors, giving notices to state agencies, things like that are related to creditors and debts. And once you ultimately have that wrapped up, you file a petition with the court to distribute the estate. And so I've extremely, yeah, exactly. And I've extremely simplified it in what I just said, but essentially that's the process, right? And it takes time, as Pete can tell you. It's not easy to work with someone whether you have an estate or a trust. I mean, you're going to have complications dealing with financial institutions and things. But the probate process requires you to file an initial petition to even be appointed to open probate, so to speak. And once and that takes a couple of months to get completed, and then someone has authority to do anything. Whereas with a trust, the successor trustee is able to take action when they have a death certificate. And for the probate, once the person has authority, there's a whole process. Notices of liquidating different assets have to be given to the beneficiaries of the estate. And that could be the intestate heirs, or if there's a will, it would be the beneficiaries. So just a note on that, even if you have a will, that will go through probate. The only way to avoid a probate is through a trust. And I'm sure that'll be discussed in one of the future workshops, but I'm happy to go over it here a little bit if you'd like. But
yeah, I can't remember how many slides we have. 5 minutes left.
One more after this about just changes, just generally.
Okay, let's go to the next slide then. Or this is the next slide. Let's talk a little bit about the taxes, and then we'll get into the questions that we've received.
Yeah, so there's tax law changes. At the end of 25, the estate tax exemption amount is going to expire, and it'll revert back unless Congress votes to extend that. So if you have an estate over $5.5 million, it would be something to consult with your estate planning attorney, but also your tax professionals that you work with, and they may need to work in conjunction with one another. And California itself has actually made a lot of changes applicable to conservatorships, trust accounting principles, and trust protectors, actually. So if you have any of those issues or concerns, and trust accounting has to come into play when you have AB splits in trust and things like that. So if you're curious about it, it's something to talk to your attorney about. As far as the upcoming elections, a lot could change. There's several propositions even in California. And a lot of that could even change in the next year just because there's a lot of deficit issues, right? And whenever you have a deficit issue, they raise taxes. So
you want to talk a little bit, spend a couple of minutes on Prop 13, which is now Prop 19. Because a lot of people are concerned about that.
Yeah, so that changed a couple of years ago. with you previously, you were able to transfer your residence to a parent was able to transfer their residence to their children without any reassessment, as long as certain notices were filed with the county. And they were also able to transfer an additional piece of real property up to $1 million valuation without reassessment. Under the new law, that additional property has been taken out, and it's only the personal residence of the parent that can transfer to the child. And there's other requirements as well. So it has to actually be their residence, and the child has to move into the residence. I believe it's within 6 months, and file a claim for the homeowner's exemption on that property. So there's several requirements for it. Previously, it was the task, so to speak, was sort of put on the trustee, but under the new law, it's now put on the beneficiary. So it's not even so much that the trustee would be aware. A lot of it is on the beneficiary to file and make the proper claims. Otherwise, they will not be able to take advantage of the reassessment exclusion. And just to clarify, this is all related to property taxes as opposed to estate taxes or income taxes, which are totally different.
We have a few taxes to be concerned about.
Yeah, and that's what I noted in here is it's a whole picture you got to look at when you're doing an estate plan.
Yeah. But it's personal, it's the good news is that we have no clue as to what's going to happen. Do you have a prediction as to what Congress is going to do?
I have no idea. All I know is they're going to keep spending and keep raising taxes, and we never know which one's going to go up, right? So
we don't.
That's the tough part, and that's why I say it's good to update things every 5 years or talk to an estate planning attorney and even tax professionals.
Yeah, you do. Before we sign off, are estate planning rules different state by state?
Yeah, they can be very different within each state. So typically, if you set up an estate plan in one state, because of the full faith and credit clause under the U.S. Constitution, it's going to be good in other states. So that's one aspect of portability. But generally, I recommend people, if you move to a different state, to speak to a local estate planning attorney so that they can look at your documents and see if there's anything unique you need to be concerned about in that state.
Yeah, it's very state specific. There is no national estate law. So be careful. Steve, if we were in a group, outstanding talk today. Thank you so much. And
thanks for having me.
Yeah, no, that was really, really helpful.